Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. All of our fees are on a sliding scale based on your income. So the less you make, the less you pay. Today, I want to talk to you briefly about the criminal charge of possession with intent to distribute. Possession with intent to distribute a controlled substance is a very serious charge, as you can well imagine. Depending on what the controlled substance is, it's either a felony or a misdemeanor. Generally, it's depending on depending on the class. Most classes are felonies. If it's marijuana, which is a class D, it's a misdemeanor, but still a very serious charge indeed. So, possession with intent to distribute. So there's several things that the Commonwealth has to prove in order to find you guilty of that particular charge. Uh, First of all, it's possession. So if you have a possession case or a possession with intent, the Commonwealth has to prove that you had in your possession. So that means you were exercising some dominion or control over the contraband, and that you did so with the intent to exercise that dominion and control, and with the knowledge of it. So oftentimes things come up where if you're in a car with other people, not your car, and there's drugs that are found in the car, we can successfully argue that you had no knowledge that the drugs were even in there. If they're not in your possession, that is in your pocket or your purse or at your feet or something. But if they're hidden away underneath the seat or something, there's a valid argument that can be made that you did not know that the drugs were there, so therefore you could not possess them. So on top of the possession charge, what they have to show for possession, they also have to show an intent to distribute. Now, how do the police and the prosecution go about proving that you are intending to distribute that particular item or items? Well, there are several things that people they look to. Certainly, if there's any controlled buys, so if a police officer is posing as a drug user and they buy off you, an easy one an easy argument for them to make. Um, in Massachusetts, it doesn't really matter. It doesn't matter how much of the drugs that were in your possession. Just because you had a large quantity doesn't necessarily mean that you were intending to distribute those drugs. So the quantity doesn't necessarily come into it, although that can be a factor. Other factors are also if the drugs are individually wrapped. So if it looks like each package is supposed to be sold to another person, that can be what they call an indicia or a sign that you are intending to distribute the drugs that are in question. If there's a scale nearby, that can go towards showing that there was an intent to distribute, that you're a drug dealer, but not necessarily. There is case law that says someone with a scale doesn't have to be a drug dealer. They could be a user, and they just take the scale along with them when they're buying their drugs, so that they don't get ripped off, so they don't get cheated on the amount that they're bargaining for. If there's a large amount of money, that can also be a sign that you are intending to distribute the drugs that are in question. So those are basically kind of the things that you look to as you're reading the police report when we're originally looking at a case to evaluate it for its strengths and weaknesses and so forth. As I say, it's a very serious charge. It oftentimes carries a jail term. Possession with intent is not one of those crimes that are treated lightly in any fashion. And there are additional facts that can bring on a mandatory minimum sentence, depending on the facts of your particular case. For instance, if you are charged with possession with intent to distribute within a school zone, that is a minimum mandatory 2-year jail term if you're convicted or if you plead to it. So within a school zone is 1,000 feet of a school, an elementary school, a public school, high school, private school, whatever, or within a short distance from, say, a playground. Beyond that, if you have already been convicted of possession with intent to distribute, so now you picked up another charge, it's considered a subsequent charge. So anything 2, 3, 4 charges are subsequent charges. Depending on, again, on the class of substance, that carries a minimum mandatory jail term of, in some cases, 3.5 years. Obviously, that would be something that has to be taken to the superior court in order to get that charge addressed, because of the felony status, and because it carries state prison time, which is associated with that. So there are a lot of things to consider if you're charged with that. As I say, you're really running a risk that it's a jail case, and that the prosecution, that is the district attorney's office, will be looking to send you to jail on that particular charge. So it's extremely important that you get an experienced criminal defense attorney on your side as soon as possible if you're facing a charge of that sort. As I said at the beginning, our fees at Afford Law are all based on your income. So that means that the less you make, the less you pay. Our whole reason for being is that we want to represent the hardworking people of Massachusetts in criminal and family law courts throughout Massachusetts. Please feel free to visit us at affordlaw.org, and feel free to book a free virtual appointment with me. I'd be happy to answer any questions you might have on possession with intent to distribute cases, other criminal matters, or anything having to do with family law. At Afford Law, we're making justice affordable.